Hi, everyone. Good morning, good afternoon, wherever you're coming to us from, and thank you for joining us for this webinar that's surrounding legal parentage. My name is Alan Osborne. I am the Chief Business Development Officer with Family Source Consultants. We're a third-party agency from Chicago with Egg Donor Program and a Surrogacy Program. And our friend Andy Vorzimer is coming to us from California today. He's a wonderful attorney in the third-party reproduction world and assisted reproductive technology world. And he's going to answer some questions we have already set up and that are coming in surrounding legal parentage. And my colleague Hannah is here to help us as well, kind of mediate. And I'm also here to chime in if there's any questions you guys might have on the intended parent clinic side of things. But very, very happy to have you join us and pass some of this knowledge on to all of you.
Perfect. And Alan had mentioned, so anyone who's watching this live, we can take your questions live. So I have some prepared. We're going to have a great conversation here today. But if you have questions and you're watching this live, please feel free to just put them in the chat and we can go ahead and address your questions in real time. So Andy, thank you again so much for joining us. We are so happy to get to talk to you today. Can you start by just telling us a little bit about yourself, your professional background, and then how you got into this field in the whole first place?
No, of course. And thank you so much for having me. It's an honor to be here with you and your team. So I've been practicing law for about 35 years now, got into reproductive law 30 years ago. In fact, today is my daughter's 30th birthday, and it was her birth that transitioned me out of becoming assisting other individuals and families to help become parents. So started doing civil litigation, a lot of constitutional law work, and in law school, I had actually written a law review article on whether or not there was a fundamental constitutional right to have access to technology like IVF and ultimately gestational surrogacy. And then after my daughter was born, was blessed to be able to have an opportunity to assist other people to start their families. And over the last 30 years, I've been blessed to have helped more than 1,000 couples start or expand their families through surrogacy. We also, assist in other types of assisted reproduction, sperm donation, egg donation, embryo donation, anything related to this industry. We help guide and advocate our clients to make sure this journey is as smooth as possible.
Fantastic. And it sounds like quite a ride you've been on over the past few decades then.
It's been a fascinating journey. When I started, it was sort of the Wild West of reproductive medicine. There were no laws, no standards, no guidelines. So sort of made it long, and it's been amazing over the last 3 decades to see how this industry has evolved, for better or for worse. But thankfully, we're in a situation now where almost most people from around the world now have access to this technology, at least here in the United States, and the ability to start a family, where 30 years ago it was primarily limited to married heterosexual couples. Now anyone who wants to be a parent can do so, as the laws have progressed and evolved over the decades.
Yeah, where do you see the laws going and technology going based on kind of where we've been even just over the last 10 years or so?
Yeah, it's a great question. So, there've been a lot of change. So, starting with the good news, and I tend to be the eternal optimist. We're seeing more states becoming more progressive as far as allowing intended parents to move forward with commercial surrogacy. States that historically prohibited surrogacy, places like New Jersey, as an example, have become a wonderful progressive state that allows surrogacy. So we're seeing more states open their doors and allow intended parents to move forward with commercial surrogacy. Many are dropping restrictions they used to have. So, historically it was limited to married heterosexual couples who were both genetically related to their children. And now we're seeing the ability of single men, same-sex couples, intended parents using donor embryos to be able to move forward. So that, on the positive side, has been wonderful. And we're up to 46 states that we can legally do surrogacy in. On the downside, we're seeing, issues like abortion, unfortunately, enter into this discussion and impacting surrogates, our clients who otherwise choose, because of restrictive abortion laws as a result of the Dobbs decision last summer. And while in most states, a surrogate can travel to a neighboring jurisdiction to have a termination procedure in those very rare cases where it becomes necessary, there are certain states that are trying to impose punitive measures against not intended parents specifically, but anyone that assists a woman in having an abortion out of state. Places like Idaho and Texas now are trying to punish them. So that's something now we have to balance when we advise our clients as far as what states work best for them. And then the other issue is insurance. The issue is insurance. I know you guys all the time, both the domestic intended parents and international intended parents. Again, starting with the good news, we're seeing states like Nevada pass laws that prohibit insurance companies from discriminating how a woman gets pregnant. So in a state like Nevada, if you write insurance in that state, you must cover surrogate pregnancies. But as you guys know, many insurance companies are trying to exclude maternity benefits for women serving surrogates. So that's a battle that we continue to wage to try to make sure that access to affordable insurance to cover the pregnancy, labor, delivery, and any complications that come up. On the international side, as you know, it's become extremely difficult to obtain newborn insurance for international intended parents that make up about 50% of all surrogate journeys in the United States. Companies like Bupa and Allianz that previously made international traveler policies available that would cover newborns here in the United States, they have pulled out of the market. So now we're left to non-admitted carriers, companies like Lloyd's of London, to offer coverage to newborns in the United States. But as you know, those policies are limited. Oftentimes, they're cost battle we continue to need to wage and make affordable insurance available, not just to gestational carriers in the United States, but to make sure that these babies are covered. They had been under the Affordable Care Act, but a few years ago when they eliminated both the individual mandate and allowed insurance companies to impose residency requirements before you can cover newborns, we've run into serious issues with the ability to get coverage for these babies. And hopefully over the next couple of years, we'll see some revisions to the Affordable Care Act in the United States, who will automatically be a U.S. citizen, will again have access to affordable insurance.
Those are really great points. I think it's so important to understand the greater political and social climate that a lot of these decisions are made in and how they impact the world of surrogacy. So,
and it's a good point, Hannah. And just to sort of close the circle on that, one other issue that I am concerned about is, as this presidential campaign begins and they start ramping up some of the rhetoric, we're seeing attacks on the LGBTQ community. And I am growing concerned that some states will try to go back to the old days where they restrict access to intended parents that may be either single or same-sex couples and limit their ability to move forward with surrogate arrangements in a safe fashion. So I know that my colleagues in this field and organizations like yours are doing everything they can to ensure equal access to this technology. But I think, unfortunately, this is a battle we're going to have to revisit. I thought we got past it in the late 90s, but unfortunately, looks like we're going to have to fight it all over again.
Mm-hmm. So it sounds like advocacy through agencies and even just individual advocacy might be kind of a solution to some of those challenges.
I think that's going to be one of the pressure points we're going to have to bring on both state legislatures and in Congress. And we do need people to step up and fight for it, because these communities just don't have a voice and they're so vulnerable right now. And, we're seeing it across the country, whether it's hate crimes or, removing books from school. Unfortunately, this has always been, and excuse the pun, a fertile ground for the political religious organizations to go after things like assisted reproduction. I've been battling organizations like the Center for Reproductive Freedoms that, quite to the contrary, what they're actually trying to do is they're recruiting surrogates in states who are pregnant, engaging counsel. Oftentimes these cases are being funded by the Catholic Church, the Archdiocese of New Jersey and Orange County, to bring litigation to try to strike down surrogacy laws that give access to intended parents. So this has been a battle we've been fighting for more than 20 years. The Center for Bioethics, I think I misspoke earlier. And unfortunately, these challenges continue, if not increase, as we start getting deeper into this political season approaching the 2024 election.
I feel like we could do a whole separate webinar just on the political landscape and how surrogacy is impacted by it. So
Yeah.
It's crazy. And it used to be, when you looked at the political maps, you had the blue states and the red states. I remember early on in my career, clients would ask me, well, what state should I focus on? I was like, well, if it was a blue state, it's probably going to be fine. New Jersey was an exception. If it's a red state, it probably would not be. But then you have states like Utah, one of the most conservative jurisdictions in the country, that has some of the most progressive surrogacy laws in the world. And then a place like, New York, Arizona, as an example, that have restrictive laws. So the battle's not over, and because these are state rights issues, it's something that unfortunately, we have to organize on the ground in each individual state. Any kind of national approach likely is not going to hit the need.
Mm-hmm. So just even backing up a little bit, like what can you define for folks watching? Because again, this will be a lot of intended parents or prospective intended parents. So what is parentage, and how is that specifically impacted then by different states?
So that's a great question. And it's one of the two most important fundamental issues all intended parents have to look at in deciding, whether they feel comfortable moving forward. The first one is whether or not surrogacy is legal and permitted in the state their surrogate lives in. But Hannah, to your question, how we establish parenthood is unique to each state and focus on whether or not we have the ability to get the intended parents' names on their child's original birth certificate and what procedure they have to complete to have that birth certificate issued. And there are two basic approaches to establishing parenthood throughout the United States as a result of a surrogate arrangement. The preferred approach, the one that sort of originated here in California, is the pre-birth order approach. And we were able to get the first pre-birth order ever in the United States back in 1996, court arguing that it was discriminatory and unconstitutional to allow a biological father's name to automatically go on a birth certificate. But if his wife, who used her own eggs to have a child but was carried by a gestational carrier, she needs to get her husband and surrogate's consent to adopt her own genetic child, that was discriminatory, sexist, and unconstitutional. And we were able to have that first pre-birth order issued back in 1996. Subsequently, I drafted the California surrogacy statute that mandated pre-birth orders across all cases, regardless of marital status, sexual orientation, or genetic connection, and that have been advocating for similar laws to be passed across the country. So the good news is there are about 24 states right now that do not discriminate any intended parent, whether they're single, married, genetically related, in a same-sex relationship, will be able to go before a judge during the pregnancy and obtain a pre-birth order that declares them to be the legal parents, terminates any rights the gestational carrier may have to their child, and orders the hospital and Department of Vital Records to place both of their names on the original birth certificate as mother and father. In other states, however, there's still some discrimination. If an egg donor is used, a sperm donor, an embryo donor is used, then intended parents are looking at potentially step-parent adoption, co-parent adoption if it's a same-sex couple, or even a full adoption if neither intended parent is genetically related. And there are obviously significant advantages to obtaining the pre-birth order. We can complete all the legal work before the end of the second trimester. So as soon as that baby is born, the intended parents can enjoy, the blessing of being parents. And fortunately require a post-birth order, whether it's a step-parent adoption, co-parent adoption, second-parent adoption, or full adoption. Then they're looking at home studies, social worker visits, background checks, court appearances, a potentially delay of 6 to 9 months before they can have both of their names on their child's birth certificate. So we try to, steer our clients to states where we can complete all the legal work, establish them as the parents before their baby is born, so they don't have to do anything but enjoy their child upon birth. There are other states, we have some creative methods available to us where we can assert the jurisdiction of a different state. So if an intended parent in California, or they had a California IVF clinic, but their surrogate lives in Kansas or Indiana, oftentimes we can get a pre-birth order out of a different jurisdiction, have it domesticated, and then have it enforced in whatever state their baby is born, so we can avoid these post-birth orders. So I don't want anyone in your audience to think that automatically they're looking at a step-parent adoption or second-parent adoption if they live in a particular state where the surrogate delivers in that state. Depending on where they live, where the baby is born, where the medical procedures occurred. We may have creative options where we can avoid the need to do any kind of post-birth parental order, their parental rights before their child's ever born.
Right, that was going to be my follow-up question then. So with the different states, if you can just talk us through a little bit of the logistics, and I know this is a question we get a lot, if the intended parents and surrogate are in a different state from each other, which state needs to be the surrogate-friendly one? Where does the attorney need to be? How does all of that work?
Yeah, happy to walk you through that. It's a really important question. So what I advise all of my clients is to focus on the state their surrogate lives in, because I take a very conservative approach to these arrangements. I want to be proactive. I want my clients to be prepared for that worst case scenario. Any kind of worst case scenario will likely occur in the state the surrogate lives in. That's where she's performing the contract. That's where she's going to deliver the baby. The intended parent's attorney, as well as the surrogate's attorney, when they draft the agreement, they're going to have a choice of law provision in the contract that will say the law of this particular state applies. Now, it may very well be the state the surrogate lives in, or as I mentioned earlier, we could choose the laws in the state that intended parents live in, where the medical procedures occur, where the baby will be born. So this is an issue that will be fleshed out before a contract is ever signed. So when the parties enter into the agreement, they understand how this journey will unfold, where we will assert parental rights, and it will be in a venue that will protect both the intended parents and the surrogate. But we do have to worry. Sometimes surrogates may have to go to a funeral out of state and they deliver in an unfavorable state. She may get relocated. Her husband could be in the military and move to another country. So all of these issues have to be addressed. So what we advise our worst case scenario, we want to look at the laws in the state that your baby will be born in, and then work back from there. So places like Michigan, Nebraska, Arizona, Louisiana are states that we're going to encourage our clients to avoid, primarily because the contracts are void and unenforceable. In places like Michigan, there's criminal prosecution available. So what we're going to want is to find a state, number one, that will allow a commercial surrogacy agreement, and then preferably also allow for pre-birth orders. The intended parents can generally come from anywhere in the country if they have a nationwide practice. Some attorneys are limited to particular regions because their level of experience and expertise may not extend to other states. But most of the attorneys in this industry representing intended parents will, because when those intended parents come to that attorney, they don't have a lawyer yet. They don't have, a surrogate yet. So that surrogate, they may not be matched with for 6 to 9 months. We don't know what state she may come from. The surrogate's attorney generally will be from the state the surrogate lives in, so she can advise her client of the local rules and any special customs or be addressed in that state. But even more importantly, that attorney then is available to assist the intended parent's attorney in filing the parental order. It avoids the need to bring in a third lawyer from that state. The surrogate's attorney works in conjunction with the intended parent's attorney, prepare all the parental order documents, and then the surrogate's attorney will file that in the state if the intended parent's attorney is not licensed in that state.
Perfect. I know that is such a complicated, there's so many layers to it. So I appreciate that.
Yeah, there is. And let me just bring up another clue with you guys based in Illinois. I mentioned Indiana. Indiana finds these agreements to be void and unenforceable. But because of the climate we're in right now, where it's so difficult to find surrogates, we're forced to work in states where perhaps we would have avoided them pre-pandemic. So there is also the ability for your audience to understand that we can relocate a surrogate. So if you have a surrogate that's in Indiana, as an example, but it's not going to be that difficult for her perhaps to travel to Illinois to deliver the baby, in a situation that Illinois would have jurisdiction over the birth of the child, and we can follow the Illinois procedure to have the intended parents' names added to the birth certificate. So for your audience, please know that even though the surrogate may live in a state, if she's close to the border and the neighboring state has surrogacy laws that are more favorable, then we'll make arrangements to have her relocate for the delivery. And that may very well be she just drives in, the day or day before the delivery, and then returns home a couple of days later. In some cases, we've actually had to relocate surrogates to California, to Maryland. It may be that they have to relocate at the 36th week of the pregnancy, but the intended but the intended parents and surrogate are the most protective legal jurisdiction possible. So we actually arrange for relocation or surrogates for delivery so we can get the intended parents' names on the original birth certificate.
So there's creative ways then, it sounds like, to solve problems here.
Without a doubt. And that's the interesting and challenging aspect of this field, is because the laws are still evolving, we have to be creative. We have to take that road that's less traveled to make sure that we can protect our clients, protect their child, and protect the surrogate and her family at the same time.
Yeah, I just wanted to jump in here. Like, how do you normally suggest to your intended parent or gestational carriers, like, how they find their attorney? Because, when intended parents are working with our agency, we don't have in-house counsel, but we do have wonderful relationships with attorneys like you that we refer them out to. Because we don't know who they are, what state they're from, usually when they start working with us, how does that normally work? Do you suggest an attorney for them because you've worked with them in that state, or?
So we do. Yeah, that's a great question. Now, we always want to be concerned, and not just on the legal side, but also on the mental health side as well, that the intended parents and surrogate are not given an attorney or psychologist. That's nothing more than a rubber stamp for the agency or IVF clinic. They need to make sure they have independent professionals. So since we almost exclusively represent intended parents, we have a census in each state. We have a list of at least 10 lawyers that specialize in this area of law. Now, there are a couple of states, places like Hawaii, where there may only be 3 or 4 lawyers that practice in this area. But for the most part, we'll provide every agency we work with a list of at least 10 lawyers in that state that have handled at least 50 cases from beginning to end, and that's one of our minimum requirements. No, issues with the state bar, that they have a clean history, significant experience in this field. And then the gestational carrier can choose any attorney she wants on the list. Now, I encourage my clients, and when we represent gestational carriers, interview multiple lawyers, interview at least 3 attorneys before you make a decision, because that attorney throughout this process is the only independent advocate that will be looking at the interests of either the intended parents or gestational carrier. When you think about it, the agencies have, divided responsibilities. You have obligations to both the intended parent and gestational carrier. The IVF doctor, which, the intended parents will choose as they begin their journey, that doctor is there for them. But once they find their gestational carrier or egg donor, then there's a physician-patient relationship that's created with the gestational carrier and the donor, with the mental health professional that does the screening on the gestational carrier. Eventually, she may become a therapist to that gestational carrier throughout the pregnancy, serve as a resource to help her address any issues that come up. So what we want to make sure is that the intended parents and surrogate have an independent attorney that will serve as their advocate throughout the entire journey, coordinate with the agency, the rest of the team, to make sure that they're protected, they're being heard, and perhaps most importantly, we can protect the relationship between the intended parents and gestational carrier. And it may seem counterintuitive coming from an attorney, but I have always advised my clients that success or failure in these relationships ultimately comes down to the personal relationship they can forge with their surrogate. Yes, the contract's important, the law in the underlying state is important, but at the end, there's personal relationship-driven arrangements, and we want to do everything we can to protect that relationship. And to the extent any issues ever come up, whether it's a relationship issue or the surrogate is struggling with some personal issue at home that may be a stressor in her life, that we have the resources available to help all parties through this, protect that relationship, because that experience has taught me that is going to ensure a smooth journey throughout the entire pregnancy.
Now I want to remind folks who are watching live, if you have a question and you put it in the chat, we will be able to answer it live. So we did have a question come in. It's kind of a specific question. So it goes back to states and international regulations and things like that. But if in this particular scenario, a same-sex couple in the UK is looking to work with a surrogate in Arkansas, I don't know how much you know about Arkansas law, but would you anticipate any issues there, or should they be speaking with their attorney in Arkansas? Any other advice for them specifically?
Yeah, so Arkansas should be a safe state if the intended parents are married and at least one of them is genetically related. In fact, it has a pretty interesting history in the surrogacy industry. Arkansas used to have the shortest residency period for anyone to become a resident. So early in my career, when we worked with international intended parents, which I mentioned are at least half of all cases in the United States, when their baby was born, we needed to be able to establish residency for them so that they could complete, because this was before we had the ability to get pre-birth orders. We needed them to establish residency and then the parental order. So we used to send our international clients to Arkansas 30 days before their baby was born so they could establish residency there. They would go to whatever state their baby would be born in, bring that baby back to Arkansas, and then we were able to file the parental order in Arkansas because they were so progressive. Not one of those states that would come sort of the top of your mind as a very progressive surrogacy state, but they have a long history of supporting intended parents, both domestic and international. So for this couple coming from the UK, I would not anticipate any issues at all, as long as one of the intended parents is genetically related to their baby.
That I did not know that about Arkansas. See, this is this is good news. So can you, I mean, we have a few minutes here, but if you can just speak to the general advice you would give to intended parents as they're trying to find an attorney, or like what they should be looking for, how they, how they find their match in that.
Yeah, so I would make 2 points. One, as far as the selection of the attorney, as I mentioned, that attorney is going to be your independent advocate throughout the entire journey. And there's really two basic approaches in this industry. There are firms that are more transactional. They're there to draft the contract and get the parental order. And then there are firms that take a much more holistic approach to the representation. So they're on board from the beginning as they engage the IVF clinic, the agency. They're reviewing all the documents. They're assisting them in the selection of a surrogate and an egg donor. They're reviewing insurance. They're looking out for those intended parents over the next 18 months. And then they're working in conjunction with the IVF clinic, the age administrator, the mental health resources throughout the entire journey. They're making the hospital arrangements. They're assisting with immigration issues, international parental orders, even down to the collection of cord blood, cord tissue, and the pumping of breast milk. So depending on what role you would like your attorney to take, there are those that will simply do the contract and the pre-birth order. But if you want someone to be an advocate and a liaison throughout the entire journey for your team, then you may want to consider a law firm that takes a much more aggressive approach, immersive approach, where they're available throughout the entire journey until the intended parents are safely home. The other major point I would make, and this is something that surprises a lot of my intended parents, is that I caution them to avoid that impulse of selecting the first available surrogate. I know how important it is for them to become parents. We're not getting younger. And when you get presented with a potential candidate, the impulse is to move forward with her because you don't know when the next candidate's going to come and whether it'll be better or worse than that first one that was presented. And I advise all my not believe that the contract or the law in the surrogate state is ultimately going to protect you. To me, it comes down to selecting the most compatible surrogate you can find. And please don't fall into that trap where you believe that you can incentivize a surrogate to change the lifestyle by giving her bonuses. It's simply not going to work. And I know, thankfully, having worked with your agency for years, you don't do that. But there are other programs out there that, they match with the surrogate, but she has a different set of values. They don't have a similar vision for what a healthy pregnancy looks like. So I have intended parents that may not want their surrogate to have foods that have artificial colors, sweeteners, and hormones. They only want them to eat organic food and practice yoga 3 times a week, as an example. Well, a lot of agencies will fall into that trap, and attorneys as well. All right, we'll give her a $5,000 healthy food allowance. We know she'll buy that organic food. That's probably not going to work, because when you think about it, if it wasn't important for her to practice yoga 3 times a week and eat organic food during her own pregnancies for her own children, she's probably not going to change for you. So please resist that available surrogate. Find someone that shares your values and vision for what a healthy pregnancy looks like. So all we're asking her to do is maintain that healthy lifestyle, not make any dramatic changes. And it's not just lifestyle, diet, exercise issues. It also includes willingness to carry multiples. As you know, when we do IVF, there's an elevated risk an embryo can split, and we could have identical twins. Termination now is a significant issue, always has been. Are we going to have to undergo a selective reduction procedure, fetal? Are we going to need to terminate an entire pregnancy? We need to make sure the surrogate philosophically, even religiously, is on the same page as the intended parents and lives in a state that will allow access to those types of medical procedures.
I think that is the absolute best advice I have heard, because there's such a human component to it that I don't think is necessarily captured in the contracts. Like you were saying, yes, this part is important, the legal aspect, of course, but it's really the relationship between these two parties that has to last in a sustainable way. So thank you for making that point.
You're very welcome.
Yeah, I had a quick question for you, Andy. You've touched on like the differences in pre and post birth order states. Are there states for same-sex couples to avoid due to their maybe archaic laws or surrounding same-sex couples and them having a child?
Yeah, absolutely, Alan. There have been states that historically have discriminated against same-sex couples. I harken back to a state like Florida, which is my home state. When they finally passed the surrogacy bill, they limited it only to married intended parents, but at the same time had a statute that prohibited same-sex couples from being married. So effectively, was how they barred same-sex couples from moving forward with surrogacy in Florida. So I think the litmus test on that is whether or not these states allow for pre-birth orders. And unfortunately, the way some of the states, sort of obfuscate their discrimination is if an egg donor is involved or a sperm donor is involved with any same-sex couple, one of those will be needed. They will not allow them to obtain a pre-birth order to go through this second parent or co-parent adoption process. So what we do is anytime a client engages us, we will work directly with the agency, provide them with a list of states that we recommend they focus their search on, and then give them a list of states that we recommend they not present a surrogate from. And it may not have to do simply with pre-birth orders. Utah, as an example, let me use that. Utah, as I mentioned, thankfully has some of the most progressive surrogacy laws in the world, that they do require to be married. And as you guys know, in many countries, same-sex marriage is not allowed. So for international intended parents coming from a country where same-sex marriage is not allowed, you cannot work in a jurisdiction like Utah. Now, we have cases where we've arranged to have our clients married by Marilyn Monroe in Las Vegas, so we can have that marriage certificate, and then we can satisfy the requirements in Utah. But for many intended parents, they don't want to have to go through that extra step. So what we want to do is advise them up front. Here are the green states that you should focus on, and here are the red states we don't want you to consider a candidate in. And then, to add to that itself, as you guys know, we have restrictive language that prohibits the surrogate from traveling or relocating, because we want to make sure that through the pendency of that pregnancy, she does not leave her state to ultimately end up delivering in a state that may be hostile towards a same-sex couple or a single individual, or even a couple that may have used embryos that were created from donor eggs and donor sperm, which would put them in a precarious situation where they would not be considered the legal parents, and then they have to undertake an adoption. And imagine an international couple finding out at the 11th hour that now they need to do an adoption of their child, which means they may be stuck in America for months before that process can be completed, and then we can obtain a passport for them to return home.
I think the take-home message too is, like, if you find an attorney that you like and trust, you have somebody on your side who can help figure some of this out for you, because I think it can be really scary and overwhelming to hear some of these possibilities, and it's definitely important to think about them and anticipate, worst case scenarios. But you're an expert in the field, right? You've been doing this, whereas intended parents aren't. That's not their job to be all the experts. That's yours, right? So being there for people and helping coach them through their options.
No, it's a great point, Hannah, and that's why we encourage our clients to engage their attorney as early on in the process as possible. As you know, traditionally in this industry, the attorney is not brought in until the IVF clinic has medically cleared the surrogate. Then the lawyer comes in and begins drafting the contract. But at that point in time, there's already been a match. There's been a financial and emotional investment into that surrogate, and the lawyer steps in and says, by the way, do they step parent adoption? And here's the delay it's going to take. You may not be able to return home immediately. And that creates frustration, disappointment. So we do encourage our clients as early as possible, have that attorney on board just to advise you. Now, our policy is our clients do not need to formally engage us until their surrogate has been medically cleared by their IVF doctor. That could be 6 to 9 months after they, have approached us. In that window of time, we don't charge for our services. We're here as a resource to help. We have profiles with them, agency agreements, doctor consent forms, surrogates insurance, work with fertility brokers to replace that insurance. And we don't ask them to engage us until we're ready to draft the contract. But having that resource available during that 6 to 12-month window from engaging the agency until you're ready for contracts, I think is enormously useful.
Absolutely. Well, Andy, I know I could talk to you all day about these things, but you have things to do, I'm sure. And we're going to have to schedule a part 2 of this, if you don't mind, in the next coming months.
No, I would love to. Thank you for having me.
Fantastic. Thank you so much for your time. We appreciate it.
You're very, very welcome. Take care, guys.
Yeah. Bye-bye.